Good afternoon, everybody. Thank you ever so much for joining us today. Roger and I will be delivering this webinar on, as you see there on the visible slide, on non-party costs orders, and that's the section that Roger will be delivering, and then I'll be giving a civil fraud update. We hope to wrap it all up, including both of our sections and some questions and answers, certainly within the hour. Now you'll see on the Zoom tab at the bottom, there's a raise hand function, and there's also a Q&A little icon there. What we'd ask is that you just ignore the raise hand function and don't figuratively raise your hands. Rather, if you could, if you have any questions, just ask them in the box, and we'll try to either answer them in writing or to deal with them at the end. And I think, unless there's anything pressing, Roger, that we need to cover, if we get cracking. Roger, I'll hand over to you then.
Okay. So, good afternoon. For those who know me, good afternoon, and those who don't know me, good afternoon again. I, like Richard, part of One Chancery Lane, soon to be Decker Chambers merged, part of civil fraud, costs, and the like. I've been doing this for many countless years, principally on behalf of the defence. Although in this case, I'm going to just be dealing with a seminar on non-party costs orders, as you can see. Now, so often, the winning litigant is faced with a hollow Pyrrhic victory over a party of little, if any, assets to enforce the cost judgment against when we win a defence, that is. Some may be content with the principled win, and in the case of a defendant insurer, the defeat of the incident claim, and of, by implication, those in the wings awaiting the outcome of the litigated claim. Now, however, it might be that the victor could consider avenues of costs against a party who was not the litigant, but is a non-party, or a third party in some terms, who the applicant submits ought to pay some or all of the costs. In this seminar, I shall briefly outline the law and procedure for applications for a non-party costs order, using particular examples of credit hire companies and a small number of rehabilitation providers in instances of rehab fraud. This seminar does not cover wasted costs against legal representatives, which is a topic in itself. Now, turning to the costs against non-parties, the court's jurisdiction is found in section 51, Senior Courts Act 1981, and also in CPR 46.2. So 51 in brackets 3 of the SCA provides that the court shall have full power to determine by whom and to what extent the costs are to be paid. So furthermore, in terms of the procedure, CPR 46.21 provides that where section 51 is being considered, a party to be added to the proceedings for the purpose of costs only, and to be given a reasonable opportunity to attend the hearing at which the court will consider the matter further. The main principles were authoritatively stated by Lord Brown of Eton Haywood in the judgment of the Privy Council in the case of Dimmock's, citations there. And essentially, although costs orders against non-parties are to be regarded as exceptional, exceptional in this context means no more than outside the ordinary run of cases where parties pursue or defend claims for their own benefit and at their own expense. The ultimate question in any such exceptional case is whether in all the circumstances it is just to make the order, and it must be recognised that this is inevitably a fact sensitive exercise with facts going for and against. Now, where however the non-party not merely funds the proceedings but substantially also controls, or at any rate is to benefit from them, justice would ordinarily require that if proceedings fail, he will pay the successful party's costs, not so much facilitating access to justice, gaining access for his own purposes. He himself is the real party to the litigation. Now, in the case of Deutsche Bank, the Court of Appeal approved the comments of Lord Brown and Dimmock's, but also set out the modern interpretation of the relevant law and case law. Both parties in that case relied upon the Symphony Group tests, if you like, but taken from that case would be a number of points. So firstly, that the procedure for considering non-party costs order applications should be summary in nature, not too protracted, unless of course the court particularly wants to give directions and the like. Cross-examination is a rarity of witnesses, but it does happen, and I've had instances myself. A costs order against a third party should only be made if it's just and fair, that the third party should be bound by the evidence given at trial and the judge's subsequent findings of fact. Whether that is so in a given case will depend on the nature and degree of his connection with the proceedings. The factors specified and considered by the court in Symphony are indicative of factors that can be taken into account in such cases, albeit they were not exhaustive, and each case should be considered on its own individual merits. So there's a bit of room there in my suggestion. Furthermore, regarding paragraph 25 in Dimmock's, as Lord Brown observed in Dimmock's, whether it was appropriate to exercise the jurisdiction to make an order for costs against a third party depends on the particular facts of the case, but in a case where the court is satisfied that the third party is effectively controlling the litigation, supporting it, whether financially or by giving evidence, and is doing so with a view to obtaining a personal benefit of some kind if successful, it will usually be entitled to regard him as the real party to the action. So at paragraph 61 to 62, further, the court emphasised that each case turns on its own facts, and that whilst there is a requirement for exceptionality, when considering making the non-party costs order, the test for exceptionality, as it is outside the ordinary run of cases where parties pursue or defend claims for their own benefit and their own expense. The court, importantly, found that the only immutable principle was the court's discretion under section 51 must be exercised justly. And it's furthermore, because it's an exercise of discretion, limited assistance is likely to be gained from the citation of other decisions at first instance in which the judge may or may not have granted an order of this kind. Now, another aspect, of course, an important aspect, is the issue of causation as to costs. So a further consideration in this regard is in the case of Travellers Insurance, Supreme Court, where Lord Briggs confirmed that causation was an important element in what an applicant under section 51 has to prove, and that if all those costs would have been incurred in any event, it is unlikely that a section 51 order ought to be made. So far as credit hire claims are concerned, as long as 2009, in the case of Farrell, the court made a non-party costs order against a credit hire company where the terms of the hire agreement and of the collective CFAs indicated that it initiated and controlled the litigation brought by the claimant. That a credit hire company may be ordered to pay costs of litigation is now expressly reflected in the rules on quocs. The rules reflect that the credit hire companies may be liable for non-party costs orders, So see, for example, CPR 4416, which provides that orders for costs made against the claimant may be enforced up to the full extent of such orders with permission of the court, and to the extent that it considers just. And that's to say where the claim includes a claim which is made for the financial benefit of a person other than the claimant. Now, the cost practice direction, paragraph 12.2, provides that examples of claims made for the financial benefit of other than the claimant within the meaning of Rule 4416 in brackets 2 are subrogated claims and claims for credit hire. So therefore, in my submission, the rules expressly anticipate that where there's an unsuccessful claim for credit hire, a costs order against the claimant may be enforced against the CHO for the financial benefit the claim was made. Now, a decision upon which the guidance is given is by Mr. Justice Turner, QC, in the case of Select Car Rentals and Eshaw, 2017. In this matter, Mr. Justice Turner rejected arguments from the credit hire company that non-party costs orders should only be made in exceptional circumstances, stating that the fact that any given credit hire organisation's connection with the claim is no greater than is commonly the case does not, without more, provide it with an automatic immunity from a non-party costs order. There is no room for the argument that it is a prerequisite to the making of such an order that such involvement be exceptional. Amongst the issues in Select, the judge found that even if the terms and conditions were standard practice within the industry, it did not give credit hire companies immunity from non-party costs orders, and that the submissions regarding the lack of control over the litigation lacked sufficient force to undermine the court's decision at first instance, which had been balanced and within the bounds of the judge's discretion. However, it doesn't all go that way, because in the recent appeal from the county court in the case of On Hire Limited and Smithson, which was handed down as recently as 20th of May 2022 in Newcastle, His Honour Judge Freedman took a more restrictive view on the facts and the application of law. The original claim, pleaded up to £28,500, comprised just 3,250 for PSLA, 12,000 for the repair of the vehicle, and just under £13,000 for the hire. Following allegations of fundamental dishonesty, the claim was actually discontinued, and at the hearing, judgment was entered for the defendant's counterclaim. The defendant also applied for joinder of on hire as to costs, and at first instance, eventually was subsequently granted a non-party costs order against them, which then became the subject of the appeal. At the appeal, it was common ground that in order for a non-party costs order to be made, the defendant needed to demonstrate that on hire were effectively the real party to the litigation, and that on hire's involvement had caused the defendant to incur substantial costs which would not otherwise have been incurred. In other words, a causal link. On hire's appeal was successful in front of His Honour Judge Freedman, who was not satisfied that either limb of the test for a non-party costs order was met. On the causation point, he found that even if the credit hire claim had been made in dispute, a trial would still have been necessary to determine liability, causation, quantum of general damages. Costs were therefore not significantly increased, in His Honour Judge Freedman's view, by on hire's involvement. The bulk of the costs would have been incurred in any event. Furthermore, there is another case which goes perhaps to the contrary, and His Honour Judge Freedman distinguished the decision here from the outcome of Gas and Bobby and First Central Management Limited on hire, where His Honour Judge Roberts allowed an non-party costs order. In Gas, liability was not in dispute, and it was the credit hire claim that caused the litigation to continue. So, as to the real party test, although it could be argued that the terms of the conditions of hire gave on hire sufficient control of litigation to be described as the real party, His Honour Judge Freedman preferred to look at what in practice, on-hire's involvement was dealing with facts on a fact-by-fact case basis. He was content with the evidence advanced by on-hire, which confirmed that the claimant made a choice to contract with them. The case pursued was his own, the claimant's, for personal injury, and that on-hire did not interfere with the litigation, nor were they provided with copies of disclosure. Now, with regards to causation of costs incurred, the court in that instance, André Friedman, was immensely critical of a statement from the defendant's solicitors, as it did not evidence, in his view, what was being asserted. He concluded that, in short, the statement goes nowhere close to demonstrating that as a result of a claim for credit hire being included, the costs of litigation were significantly increased. Much more detail was required, and it needed to be supported by documentary evidence. The statement, frankly, leaves many questions unanswered. So the outcome of this case will warm the hearts of respondents and claimant credit hire companies to such applications, who regard it as a good illustration of, firstly, the difficulty in proving that a credit hire company is a real party to the litigation, on the basis that merely being a credit hire company with a shared commercial interest in the proceeds is not, without more, enough. And secondly, how causation is to be considered as a sort of but-for test, by looking to see whether any conduct by the credit hire company can be said to have caused the incurrence of the effectively additional costs. On the other hand, applicants for non-party cost orders against credit hire companies would no doubt emphasise the fact-specific nature of these applications, citing the fact-specific basis set out in the case of Deutsche Bank referred to earlier. Nevertheless, applicants should be aware of their burden to prove in sufficient detail the facts asserted in the application for a non-party costs order, and importantly, to choose the strongest cases wisely. No doubt counsel and together with the insurer, client and solicitor can choose and help in that process. I might say, just in terms of a recent example of a non-party costs order application in which I was involved over the long course of the case, both the substantive case and the costs application. I won't read out the names of the parties for privacy purposes, but let's just call it an insurer against a credit hire company, which was heard for the cost purposes in Wakefield County Court on the 17th of August 2022, so quite recently. In that case, following an early trial, I obtained a fundamental dishonesty finding of effectively a staged slam-on collision. Subsequently, I was instructed, and we did do a non-party costs application that resulted eventually in a third-party costs order against the credit hire and storage company, who were ordered to pay 2/3 of the defendant's costs of defending the claimant's claim and 100% of the defendant's £15,000 application costs. So there are examples either way in this case of credit hire, as you know, and I dare say it's fact by fact basis, and I even dare say it's judge by judge basis. But whatever the case is, at the coalface of the county court, it's really often, typically the case that you're dealing with a district judge, sometimes a DDJ, usually the one who dealt with the original trial, who often has a very big list of other things as well in that day. So it's not often that cases get appealed to the next level where somebody's objecting to the outcome. So you've got a couple of cases there where that's gone either way, and most recently in the case of André Friedman, a slightly more restrictive view. So I now turn just briefly to rehabilitation, fraud and non-party costs orders. In that regard, those who defend personal injury claims are increasingly used to seeing rehab-based special damages claims. Insurers and policymakers should be aware of dishonest layering of rehabilitation special damages. Being alert to this is important because they can be relied upon to damage credibility, and challenge legal advisors on perhaps wasted costs and support arguments of dishonesty and fraud. I would refer you, if you have time, to an article on my Chamber's website, which I wrote and also was published in Voice for the Forum of Insurance Lawyers newsletter, in which 3 of the cases that I've been involved in have been set out. One of those cases, which is called Elvidge and Cover Insurance, from 2021, reported in Lawtel. Only the substantive trial aspect is, and some of the issues as to fundamental dishonesty and cross-examination of some of the parties and the physiotherapist involved is reported in Lawtel. But there is also a costs aspect which isn't reported elsewhere, and I'll just deal with that now. So the original judgment was in 15th of January 2021, but the non-party costs order was in August 21. So effectively, there, following an RTA in 2017, a claim was issued for damages, including £319 for physiotherapy treatment, which was said and pleaded in an invoice to comprise of 6 treatment sessions and initial assessment. Under cross-examination, the claimant denied having seen a physiotherapist. He had a home exercise pack, and he agreed that to claim for 6 treatment sessions was false. The alleged treating physiotherapist and director of the rehab provider at relevant times was called in an adjourned hearing with directions, along with the solicitor for the claimant, for cross-examination. There, District Judge Skalski Reynolds rejected the physiotherapist's explanation that being sent a leaflet, and it was only a small, if anything, leaflet of not a lot, of exercises with instruction to do them on specific dates amounted to treatment sessions. He acted dishonestly in authorising the issue of a fraudulent invoice intended to mislead the defendant. A copy of that judgment was ordered to be sent to the relevant HCPTS Conduct and Competence Committee, who dealt with the professional aspects of the physiotherapist. So subsequently, I settled under instruction and advocated for a non-party costs order against the alleged treatment providing company who employed and he was a director of. The full application was heard on the 11th of August 21, and in a scathing judgment, the judge granted the non-party costs order application and awarded multi-track costs subject to assessment from the 9th of July 19, so a considerable period, prior to which the claimant still remained liable. And just as a flavour, a very clear message was to be sent to anyone presenting fraudulent invoice who can expect to receive an adverse cost order against them. In that case, just in passing, the judge also cited another example of rehab fraud and non-party costs, which is the case of Skyfire Insurance against QTP Solutions Rehabilitation in Bradford, County Court, District Judge Mitchell, 8th of March 20, and on a slightly different vein, there was physiotherapy, well, not physiotherapy, there was various rehab treatments, CBT, that sort of thing, claimed that just wasn't so. So, in summary, costs against non-parties is a valuable weapon in terms of seeking costs. There is a wide discretion. Applicants need to think carefully about the cases to push for such applications and to prove their burden with evidence of sufficient detail. On the other hand, respondents to such applications will seek to distance themselves from being deemed in control of litigation. I hope that assists. Thank you for listening. Over to you now, Richard.
Hello, everybody. Right, let's see if I can actually get that to change slide. Bear with me. Let's try that one instead. Okay, right, brilliant. There we go. Good afternoon again, everybody. I will be covering the civil fraud section of this talk. Really, I'm going to be talking about some very recent and fairly recent decisions on fundamental dishonesty. And as we can see from this slide, there'll be two themes to what we're talking about. So firstly, this issue of adequate warning. So really, was the claimant put on notice of what the defendant's case was going to be and their intention to allege fundamental dishonesty? So decisions like Howlett, I mean, we all know about Howlett now. I'm just going to quickly recap. So Mustard, and then a very recent High Court decision in Jenkinson. And then this issue of substantial injustice, which is relevant to Section 57 situations, to call them that. So again, the decision of Sinfield, which we all know, but we recap very quickly. Idon, which is a really interesting case and judgment, very useful judgment, which I don't think has quite had the attention paid to it that it should have. And then also a more recent decision in Woodger. Now, I should say at the outset as well, this body of law, fundamental dishonesty, is it's a fairly new area, relatively. It's certainly developing. I think there's a lot of uncertainty in it. It makes it very, well, I say interesting, that might just be because I'm a bit of a loser, but it is interesting. It is more complex than I think people understand. And I do think that there are arguments to be made on either side that perhaps aren't being made currently. That's all I'll say on that. I intend to keep my talk limited quite neutrally to just an overview of the objective legal dimension. I'd be more than happy to give more strategic, tactical advice on, I think, what these legal developments and what the parts of these judgments actually mean and how they can be deployed. I'd be happy to give that training on a more bespoke basis to firms. But today, I'll keep my powder dry on those issues. So, adequate notice. It's an issue of procedural fairness, and really that. And I should say at the outset, I've got an absolutely wild number of slides, and only so much time to get through them. So there may be 30 slides that I pretty much get by and just say, it's there. The slides will be available. They'll either automatically be sent to you or be sent upon request by the wonderful Emma Williams in our chambers, who's our marketing guru. So you'll have access to these slides anyway. So if I do skip over them, don't fret. Not that you would. But yes, so adequate notice is an issue of procedural fairness, which is really, if the defendant's going to be saying at trial, is going to be asking a judge to make a finding that the claimant's been fundamentally dishonest, it's only fair and proper that the claimant should have been aware of that to the extent that they could respond, and that they were aware that their honesty was being challenged, and the reasons for it. The consequence of a claimant not being given adequate notice is that the judge then can't make that finding, and Quox therefore won't be dislodged by CPR 4416. And it's an important thing to remember with FD, is that it's really just it's a procedural tool that concerns the enforceability of a defendant's cost order following the dismissal of a claimant's personal injury claim. And that's all it does, is it allows the defendant to enforce its cost order, where otherwise the claimant will be protected by Quox. Now the issue here is, what do defendants need to do? What constitutes adequate notice? Now there is a spectrum here between raising it front and centre in pre-action correspondence, in a pleading, in every item of correspondence, explicitly pleading fraud and making it completely clear. Obviously, the claimant knows if that's been done. The other side of the spectrum is never mentioning it, don't plead it, don't refer to it in correspondence, don't set out anything upon which you're saying that you have suspicion about the claim, or you're challenging the claimant's credibility, and then it's not cross-examined on, and just following judgment, an application is made for the finding. Those are the two ends of the spectrum, and I think where there is ambiguity in the law at the moment is whether situations that fall somewhere along that spectrum satisfy this adequate notice requirement. So if we move on, Howlett, we all hopefully know about Howlett now. It's possibly a little misunderstood as just saying you don't need to plead fraud, that's it. It's a bit more nuanced than that. That's certainly correct, but if you read the judgment, there's a little more to it. So yes, the defendant explicitly in the defence in this case didn't assert a positive case of fraud. In fact, it said no, it's not a positive case of fraud. But pointing more towards raising suspicion and dishonesty was that the defendant in the defence didn't accept that the accident had happened as alleged or at all, and then raised a number of what I've described there as suspicious problems with the claimant's case. And what was described by the judge, this is a really, I think, critical piece of judicial dicta here. Facts from which they would be inviting the judge to draw the inference that the plaintiff had not in fact suffered the injuries he asserted. And that is where fraud hasn't been explicitly pleaded. I think this is a really important feature. Whether or not the defendant in the defence has set out the facts, the reasons that they're saying, we think this claim might be dodgy. And that's that little passage from Lord Justice Newey is cited in a number of other cases. It's been applied, time and time again. So I think this is something the defendant really should be looking at. The defence in Howlett expressly stated that credibility was an issue, and did state that if any elements of fraud were found, it would seek to reduce damages payable and would seek the appropriate cost order. So there is a slightly sort of cloaked reference there to FD in 4416. So in that case, as we all know, Court of Appeal upheld FD, and that's, I think, the particular relevance of Howlett is that it's a Court of Appeal decision. FD generally, there is a dearth of, or there's a complete absence of senior court appellate guidance on it. It's mostly circuit judges in the county court or high court decisions. So this is of particular relevance because it is Court of Appeal. And the key bit there is underlined, whether there's been adequate warning of and a proper opportunity to deal with the possibility of the FD conclusion being drawn. And so there are 2 points there, 2 things to consider with adequate warning. In advance of trial, was sufficient notice given? And then at trial, were these issues sufficiently explored during cross-examination? So it's really before trial and during oral evidence. Those are the 2 sort of parts to this. Moving on from Howlett, there is a lot more to say about it, but it wouldn't really constitute an update if I was spending loads of time talking about a 2018 decision. Mustard and Flower and others. So this is a 2021 High Court decision. It concerns contingent or provisional pleas of FD. And in that case, this is Master Davison, the defendant had applied to amend its defence to a personal injury claim to include the following paragraph. And it's useful here to consider the actual, the language of the proposed amendment. So I've underlined this sort of key bit there, but the first bit is just the defendant saying the claimant has either consciously or unconsciously exaggerated their symptoms. Defendant can't say without having explored these issues at trial. And then the proposed amendment was In the event that the court finds that the claimant has consciously exaggerated the nature and or consequences of her symptoms and losses, the third defendant reserves the right to submit that a finding of fundamental dishonesty, bracket, and the striking out of the claim pursuant to section 57, going on, and or cost sanctions, including disapplication of quote, close bracket, is appropriate. Now, one might have some sympathy with this, the third defendant here seeking to make this proposed amendment, given the really endorsement of the Court of Appeal in Howlett of what I described before as a slightly cloaked reference to FD. So I certainly understand why the third defendant used the language in these terms. And the explanation by counsel in that case, who was was Mr. Audley QC, was that the defendant wasn't making a positive averment of dishonesty, but was alerting the claimant to the nature of its case, explaining it was intended to cross-examine on this basis. And the final sentence said the purpose of the amendment was to ensure that the claimant was not being ambushed. So essentially explaining, we think you've exaggerated your symptoms. We won't know, the judge, we don't have enough to really, invite a judge to make that finding without exploring it during cross-examination. But to put you on warning, this is what we're saying, and if you are found to be dishonest, we'll be seeking the consequences of section 57. And it was described by the judge as a provisional plea proposed, is simply giving the claimant fair warning the defendant may, if the evidence turns out a certain way, make an application under section 57. But Master Davison refused the application. And I have included possibly the worst joke ever in brackets there. I've forgotten, it's been a while since I've done a webinar, and I've forgotten that webinars are the single worst forum ever for making jokes, but I did it anyway. I can only apologise. I couldn't resist. So yeah, Master Davison, 3 reasons for refusing the application. It didn't serve a purpose because the application under section 57 can be made without it having been foreshadowed in pleading. It's not a right which can be reserved. As a matter of pleading, that's probably correct. I think it's missing the point of what the third defendant was trying to do, which was to put the claimant on notice. It wasn't there as a formal requirement to reserve a right to do it, but was putting on notice. But, strictly speaking, that's right. Second point, present on the evidence, the plea of FD has no real prospects of success. Now that, I think, is important. So the legitimacy of seeking the inclusion of this plea in the defence does seem to have hinged on the prospect of success on FD. Number 3, it causes prejudice to the claimant. So the reasons there why it's a headache for claimants. So they have to report it to the legal expenses insurers, and opens a theoretical possibility of the insurer avoiding policy ab initio. There's added burden on costs, and causes fears and anxieties. There are things to say about that judgment, but I'll reserve comment for now. That, as it stands, is what's been said on provisional contingent pleas. There's also a very, I think, significant passage here as a general statement. It's obvious, but it's a general statement on pleading requirements generally, and it's that the judge is saying, I emphasise that nothing in the foregoing is intended to detract from the modern, quote, cards on the table approach. So where the defendant does have the proper basis, they should be setting that out explicitly. And the judge said, what I'm intending to discourage are pleas of fundamental dishonesty which are merely speculative or contingent. So quite clear there, don't make contingent pleas, or at least on the basis of what Master Davison said. This is Mr. Justice Chowdhury in the very recent High Court case of Jenkinson against Robertson. This is worth reading because there's an interesting analysis of the state of the law on this pleading issue. In that case, the defendant raised FD for the first time at trial, not having previously given express notice of its intention to do so. The pleaded case merely put the claimant to proof on the injuries and symptoms, and in correspondence, the defendant had asserted that the claim was exaggerated and unreasonable. Now, that wasn't deemed to be enough. In terms of those two elements, so putting the claimant on notice, one being before trial, one being at trial during oral evidence, merely in correspondence saying that the claim was exaggerated and unreasonable isn't enough in advance of trial. At least Mr. Justice Chowdhury decided. And then it's not enough in cross-examination to just put to the claimant that he had not been suffering from the pain alleged at the points in time that he claimed he was. Now that's quite telling as well. So counsel cross-examining at trial has to go further than that in putting the case and challenging the claimant's honesty. There's a good quote there: a vague and deliberately unparticularized allusion to the possibility of a Section 57 application did not suffice. Now that ties in, to a degree, with the decision of Musters. So I think both these decisions are pointing towards a requirement that defendants need to particularize these pleadings. Again, if you go back to Howlett, what was significant in that case is that the defendant had set out the facts on which they were going to be making, to setting out the reasons, even though they didn't actually explicitly plead for. And it says here, this is just if a case that you're handling happens to involve a claimant who's a litigant in person, that is a factor to consider in assessing the adequacy of notice. Useful guidance in Jenkinson, I'm not going to read this out, but in terms of how to approach Section 57 cases, this is quite a useful little sort of checklist. If you're really keen as well, there's the decision of Pincus against Direct Line, 2018 High Court decision. It's an interesting point that's made. So did the claimant have the opportunity to deal with those issues by way of additional evidence, and if necessary, including from his experts? So if the defendant had put the claimant on notice of these issues, of these problems earlier on, could the claimant have dealt with them by way of, disclosing more evidence or doing a supplementary witness statement, or asking Part 35s or something like that from a medical expert? Again, I think this stresses the importance of that point in Howlett about setting out the facts on which the defendant's case lies, because that allows the claimant to then realise what the important issues are, and if they can get extra evidence to deal with it, then they can go off and find that or speak to the medical experts or something like that. And that again touches on why a vague and unparticularized allegation to or reference to Section 57 or CPR 4416 is not really good enough, because what does that allow the claimant to do? They need to know what the issues are, so that, as was key in Pincus, if it can be dealt with by way of extra evidence, then they can do that. That also, to some degree, strengthens the defendant's position, because if there is no extra evidence that's forthcoming, if they've had the opportunity to deal with it, then that's quite telling. Moving on. Okay, so that's everything on adequate warning. I am running out of time, so I'll move straight on. Substantial injustice. So this is relevant to Section 57, subsection 2, which concerns the consequences of the court having made a finding of fundamental dishonesty in relation to the primary claim or related claim under subsection 1. So subsection 2 is saying the court must dismiss the primary claim unless it is satisfied that the claimant would suffer substantial injustice if the claim were dismissed. This is a very developing area. I haven't experienced, I haven't had any cases of mine in which a finding of FD the application of Section 57 has occurred, and that a judge has refused to dismiss the claim because of substantial injustice. But the time will come when there's a reported decision where it's identified. So I think it's really important to be aware of what the underlying law is. As we all know, Sinfield, again, really interesting and enlightening judgment, establishes that the mere loss of damages alone, to which the claimant is genuinely entitled, does not satisfy. Again, as we all know, Section 57 applies where there is a genuine part of the claim. So the claimant has those, let's call them genuine damages. But what happens with the operation of Section 57 is that that claim gets dismissed, notwithstanding that it's genuine, because of the dishonesty. But the value of those damages is still needs to be assessed by the judge, because that sum, the sum of the genuine damages, is subtracted from the defendant's costs, which they can get from the claimant. But yeah, the loss of those damages is not enough to constitute substantial injustice for, I think, pretty obvious reasons, really. The recent decision is in Woodger. So this is a High Court decision of Mr. Justice Knowles, reiterated that. Now, I'm not going to go into detail on the facts here. I think just these 2 points will suffice for now. Again, worth reading this judgment. But reiterated that substantial injustice has got to mean more than the claimant losing the damages to which they're genuinely entitled. Also, that the care provided by third parties should not feature in the assessment, because the language of Section 57(2) makes clear that it has to be the claimant person who would suffer the injustice. So what was said in that case is that, well, there would be substantial injustice here because part of what the claimant's claiming for here, and part of what the genuine damages would be, is money that will go off to third parties who provided care to the claimant. And it's unfair that they miss out on that money because of what the claimant's done. But that was rejected by Mr. Justice Knowles because the language is the claimant personally. So just be aware, if that is raised, as a claimant litigator, that may not be a good point. And as a defendant litigator, if that does crop up, just remember that this is the case to go to. And the judge also in that case applied IDON, which we'll come on to now. IDON is an interesting case. It's slightly sensational in the true sense of the word. It's also a very sad case because it was a lady who had a clinical negligence claim against her GP for a misdiagnosis of breast cancer. The defendant admitted breach. She was certainly wronged, and she, by the facts that are discernible from the judgment, definitely had a really miserable time of it. She had a really miserable few years, and certainly suffered some loss. She valued her claim at close to £1 million, which was largely on the basis that she was in so much pain and so much functional restriction as a result of the problems that she was experiencing, that she couldn't really do very much. Part of her evidence, part of what she described to her medical experts and in her first witness statement, was that the pain left her unable to run or swim. Now, I'm simplifying the case here quite drastically. There are a lot of other features, but I think what the key features were that there was then social media evidence of her taking part in endurance runs and swims, and there was evidence from an intelligence analyst that was accessible online. So records of her taking parts in events and things like that. When the defendant disclosed the witness statement of the intelligence analyst, which exhibited all of this evidence, the claimant attempted to explain it away in quite a novel way, which was what I've labelled there the cannabis defence. So she said, "Oh, well, what happened was that I couldn't swim or run, but I was able to deal with the pain if I used this cannabis oil that I had I think it was like a 10 milliliter bottle of that my husband had procured for me. but I didn't want to explain that I had, or disclose that I had taken part in these events, because if I did, I'd also then have to fess up to having used this cannabis oil. Not a particularly good explanation that the judge dealt with in quite a forthright way. What was relevant is that she recruited her husband and her friend into supporting the dishonest account. So they filed and served witness statements from them, I believe, which in the end weren't actually signed. They didn't turn up to give evidence at trial. But she, in a later statement, she served a number of statements, and in the final, one of the final ones, she accepted that she had recruited them into providing, dishonest evidence which supported her dishonest account. A slightly ridiculous little feature of the case is that in her supplementary statement, there was a part of it dealing with the previous statement and the dishonest parts of it, which was headed "Omissions and Lies," which is not a great position to be in as a claimant seeking to dissuade a judge from making a finding of dishonesty, where in your own statement you have got a subheading "Omissions and Lies." The judge in that case, so His Honour Judge Sefton QC, who was sitting up as a High Court judge, valued the genuine part of the claim as 70 grand. So there has been a considerable dishonest inflation of the value from the genuine part of 70k to close to £1 million. Perhaps unsurprisingly, the judge, given the findings, did find that there had been fundamental dishonesty. But given that there was a genuine part to the claim, it brought it into Section 57 territory. So the assessment turned to whether dismissal would lead to substantial injustice. Claimant counsel raised a number of arguments. So first, she'd apologised. Second, if her claim was dismissed, she wouldn't be able to get the therapy that she needed. Third, that a tort visa would escape a liability that's rightfully hers. And fourth, that she'd used interim payments, which were about 100 grand from memory, to purchase her current home, which she'd have to sell if Section 57 operated in the normal way. The judge dismissed all four. Number one, and a pretty good point, the apology wasn't a genuine one. It was only offered once she'd been caught out, and she didn't actually provide a truly honest account. She just provided another dishonest account, which was trying to explain away the dishonesty in the first one. Some dishonesty layered on dishonesty, which is not great. Query there whether, if a claimant unprompted, just midway through, just fessed up and said, "Oh, this is a lie," whether that would be more relevant. It probably would, but that would be really surprising. One would expect a claimant in that situation just to, without explaining, to discontinue. So reasons 2 and 3, so the therapies and the defendant tort visa, the judge said, well, these are inevitable corollaries of the operation of the statute, which is, again, yeah, very fair. And number 4, rejecting the interim payment point, but the judge did recognise, to the effect of this being a better point, but nonetheless dismissed it, saying any claimant who receives an interim payment runs the risk that the court will exercise the power to order repayment. And the claimant does not have a defence to an order to repay merely because he has changed his position. So again, bear in mind, if there is an interim payment and the claimant's done something in reliance on that, using that money, and have changed their position, sort of like a estoppel point, that won't bite, or at least according to Idon. Again, what's very relevant, when I'm running out of time, be quick. What was really relevant in Idon, and which was commented on by Mr. Justice Knowles and Woodger, was this balancing exercise, and it isn't actually described explicitly in that way by the judge in Idon. Nowhere does the judge say, "Oh, and now I'm going to conduct my balancing exercise." It was done in effect, really only in paragraph 103, but you'll see there that the judge is weighing. So, well, in my judgment, the culpability and extent of her dishonesty far outweighs any injustice to her in dismissing the claim. So that seems to be suggesting that even where there are valid points identified by a claimant pointing towards substantial injustice, the judge still needs to weigh how bad their dishonesty was. Query, is this the correct approach? I'll leave that question where it is. But that seems to be, at least this line of high court authorities, that seems to be suggesting that's the correct approach. But I think point number one for defendants and for claimants is to think, okay, well, what can we point to that would constitute substantial injustice? You can't just say that they lose their damages. It's got to be more than that. But I think it is really important for claimant litigators to be thinking, and this goes to everybody, not closing your eyes to FD. It is an inevitable feature of modern personal injury litigation. We can't close our eyes to it. We've got to understand it, not just the academic law, but practically what that means for what we need to be doing with our clients. So, for example, if there is a material risk of FD in your case, speaking to the client in advance about what might, if this operated, what would the effects be, and trying to formulate a way that, or trying to formulate an argument for substantial injustice. Yeah, that's, and also just a quick one. Paragraph 96, I haven't quoted it here because it's massive, but this is the judgment of it on. It quotes a useful summary of Lord Justice Moses in the South Wales 2011 decision about the, quote, toxic effects of dishonest claims. So just as a sort of a useful bit of commentary about why these claims are so damaging, that's there. Insofar as you ever have need to find a nice little neat bit of judicial commentary on it. Okay, that is then the end of the webinar. We are 2 minutes shy of the hour. There haven't been any other questions.
Can I just thank you for that, Richard. That's very helpful. If you don't mind, can I just add a couple of points in the very short time we've got left? And that's that, first of all, regarding the Jenkinson case, perhaps from a defence perspective, I would try and distinguish it on the basis that one was dealing with the litigant in person, albeit described as an experienced one. And secondly, that the allegation of dishonesty was really something that came up at trial, but even then only expressly in closing submissions. Secondly, there was one question, I'm not sure whether you answered, Richard, my attention might be moved for a moment, but there was one question that came early before the seminar regarding effectively whether or not there's a moot point at the moment regarding whether or not PI FD results in strikeout of special damages, for example, credit hire. And now those in this arena will know that there's some moot points there with leading counsel giving various opinions. There hasn't really been, I can't give any particular opinion myself other than to say that the case law is what it is at the moment, which is Bashir and Larizadeh in 2019, which is quite an established case, that indeed the special damages would get struck out. Furthermore, the High Court case of Roberts and Kesson made a similar point in 2020, that it's all of the claims struck out where one of it is. But there is some caution here, I detect, and whether or not some people are even arguing it at trial, or whether they're trying to go for different angles, such as Summers and Fairclough, the original common law test, but albeit that's quite a tough test to get, I would suggest. But if one is cautious from a defence perspective, obviously it's a case of picking the cases, and also perhaps in this climate making sensible Part 36 offers, just in case. For example, the FD, it applies to the PI but not to specials. I think it's slightly in the air at the moment, but I would be prepared to argue that it does. I hope that assists.
Yeah, thanks for that, Roger. I won't add anything to that because I handled it well. Finally, just to say thank you very much all for listening. As hopefully you're all aware, One Chancery Lane is no longer to be. It is going to pass away as such, because we are merging with Nine Golf and becoming a new, wonderful, glitzy, super strong, super fast, super set.
Rather than pass away, I think the phrase might be pupate.
Pupate, yeah, there we go, much better. Yeah, so we're going to be Deca chambers as of, I think, the start of next week. There is also, and this will be under the new name, the new branding, etc. The next webinar is on the 6th of October. It's consenting for neg claims, and it will be done by Ella, John, and Ali Rood in the new combined chambers. You can see there are email addresses at the bottom for Audra and I. Obviously, very happy to take any instructions in these cases. As I said, I can't speak for Roger here, but at least I personally would be very happy to deliver training following up on any of these points on a more bespoke basis. And
ditto.
Yeah, great.
Right.
And
get to your lunch, everybody.
Sorry?
And everybody can go now and enjoy their lunch.
Yeah, exactly. Right. Thank you very much, everyone.
Thank you for joining us.
Have a nice day. Cheers. Bye.